The March 2025 Visa Bulletin just dropped. And if you're an EB2 green card applicant, you need to hear this right now. Social media is exploding with claims about massive priority date movements, historic advances, and once-in-a-lifetime opportunities. Some people are calling this a gold rush. Others are panicking because they don't understand what's actually happening or whether they're affected. If you've been waiting for your employment-based green card and you're confused about what these numbers actually mean for you and your family, stay with me. I'm going to walk you through exactly what changed, what didn't change, who benefits, and most importantly, what you should do next based on actual immigration law, not hype. Let's start with the facts. The March 2026 Visa Bulletin, which was published by the U.S. Department of State, shows significant forward movement in the EB2 category for certain countries. This is the official document that determines when employment-based green card applicants can move forward in the adjustment of status or consular processing stages. Every month, the Department of State publishes this bulletin, and it contains two charts that matter to green card applicants. The first is called the Final Action Date Chart, also known as Chart A. This chart tells you when your priority date must be earlier than the listed date for your green card to be approved. The second chart is the Dates for Filing chart, also known as Chart B. This chart tells you when you may be eligible to file your Adjustment of Status application, Form I-485, if U.S. Citizenship and Immigration Services has authorized the use of that chart for a given month. Now, in the March 2026 Visa Bulletin, the EB2 category for India moved forward significantly. The final action date for EB2 India advanced from September 1, 2012 to January 1, 2013. That's a jump of approximately 4 months. For applicants from China, the EB2 final action date moved from April 1, 2020 to June 1, 2020, which is a 2-month advancement. For all other countries, including those born in countries without per-country caps, the EB2 category remains current, meaning there is no backlog and priority dates are not restricting green card approvals for those applicants. This forward movement is what has generated excitement online, and people are using terms like gold rush to describe the situation. But let's be very clear about what this actually means. The term gold rush implies a sudden, unexpected windfall that everyone can take advantage of immediately. That's not how the U.S. immigration system works. What we're seeing is normal month-to-month movement in visa availability based on demand, visa number supply, and processing capacity. The movement is positive, and it's meaningful for people whose priority dates fall within the newly advanced range, but it's not a fundamental change in immigration law. It's not a new program. It's not a policy reform. It's the regular monthly update that happens every single month, and it reflects the ongoing administration of the employment-based green card system as it exists under current law. Here's what you need to understand about priority dates. Your priority date is established when your employer files your labor certification application, known as a PERM, or in some cases, when your Form I-140 immigrant petition is filed if you're exempt from the labor certification requirement. That priority date is your place in line. The Visa Bulletin tells you whether your place in line has been reached. If your priority date is earlier than the date listed in the final action date chart for your category and country of birth, then a visa number is available to you, and your green card case can be approved if all other requirements are met. If your priority date is later than the date in the bulletin, you're still waiting, and no approval can happen yet, regardless of how far along your case is in processing. The March 2026 movement means that thousands of EB2 applicants, particularly from India, whose priority dates fall between September 2012 and January 2013, are now eligible to have their green cards approved if their I-485 applications have already been filed and processed. For those who have not yet filed their I-485 because their priority dates were not current, this movement may allow them to file now, depending on whether USCIS authorizes the use of the Dates for Filing chart. This is significant and positive for those individuals and their families, and it represents progress after years of waiting. But it does not mean that everyone in the EB2 category suddenly gets a green card, and it does not change the timeline for people whose priority dates are still outside the range that moved forward. Let's talk about why this movement happened. Visa numbers for employment-based green cards are limited by law. Under the Immigration and Nationality Act, there are approximately 140,000 employment-based immigrant visas available each fiscal year, and those are divided among 5 preference categories: EB1, EB2, EB3, EB4, and EB5. Within each category, no single country can receive more than 7% of the total annual limit. This per-country cap is what creates the backlogs for applicants from India and China because demand from those countries far exceeds the 7% allocation. Every month, the Department of State evaluates how many visa numbers were used, how many are remaining, and how many cases are ready for approval, and then they determine how far forward the priority dates can move without exceeding the available supply. The movement we're seeing in March 2026 suggests that there was lighter than expected demand in recent months, or that processing has not kept pace with visa availability, allowing the dates to advance more than usual. It could also reflect adjustments in the Department of State's projections about demand for the remainder of the fiscal year. These are technical, administrative factors, not changes in law or policy. The system is functioning as designed, and the forward movement is a result of the normal operation of that system. Now, let's address some of the confusion and misinformation that's spreading online. Some posts are claiming that this is the biggest movement in EB2 history. That's not accurate. There have been larger single-month advances in the past, particularly during years when visa numbers went unused and rolled over, or when administrative adjustments were made at the end of a fiscal year. This is a notable advance, but it's not unprecedented. Other posts are suggesting that everyone in EB2 should immediately take action or risk missing an opportunity. That's misleading. Your eligibility is based on your priority date, not on how quickly you respond to a visa bulletin. If your priority date is current, you can proceed. If it's not current, you cannot proceed, regardless of how fast you act. There is no first-come, first-served element once your priority date is reached. Your case moves forward based on the normal processing timeline at USCIS or the National Visa Center. Some people are also confusing the dates for filing chart with the final action date chart. This happens every month, and it causes unnecessary panic. The dates for filing chart allows you to submit your I-485 application early, before your priority date is actually current for final approval. This is beneficial because it allows you to get your application on file, apply for work authorization and travel documents, and begin the processing timeline. However, your green card cannot be approved until your priority date reaches the final action date chart. Filing under the dates for filing chart does not mean you'll get your green card immediately. It means you can start the process. USCIS decides each month whether to allow use of the dates for filing chart, and that information is published on the USCIS website alongside the Visa Bulletin. You must check both sources. Let me also clarify what has not changed. The annual cap on employment-based green cards has not changed. The per-country limits have not changed. The eligibility requirements for EB2 classification have not changed. The processing times at USCIS have not changed. The backlog for India-born and China-born applicants has not been eliminated. What has changed is that the line moved forward, and some people who were waiting are now closer to or at the point where they can receive their green cards. That's good news for those individuals, but it's not a systemic reform, and it doesn't mean the underlying challenges of the employment-based immigration system have been resolved. So what should you do if you're an EB2 applicant? First, check your priority date. This is the date on your Form I-797 Notice of Action when your I-140 was approved, or it may be the date your Perm Labor Certification was filed. Compare that date to the final action date listed in the March 2026 Visa Bulletin for your category and country of chargeability. Remember, your country of chargeability is usually your country of birth, not your country of citizenship or current residence. If your priority date is earlier than the date in the bulletin, your case is eligible to move forward. If your priority date is later, you're still waiting. Second, if your priority date is now current or approaching current, and you have not yet filed your Form I-485, contact your immigration attorney or your employer's immigration counsel immediately. You need to prepare and submit your adjustment of status application as soon as possible. Do not attempt to do this on your own unless you are extremely familiar with immigration procedures. The I-485 application is complex. It requires substantial documentation, and errors or omissions can cause delays or denials. Your attorney will guide you through gathering the required civil documents, medical examination results, financial evidence, and other materials. They will also advise you on whether you're eligible to file under the Dates for Filing chart if your priority date is not yet current under the Final Action Date chart. Third, if you've already filed your I-485 and your priority date is now current, your case should be moving toward approval. However, USCIS processing times vary widely depending on the field office handling your case. Some offices are faster than others. You may receive a request for additional evidence, known as an RFE, or you may be scheduled for an interview. Monitor your case status online through the USCIS website, respond promptly to any requests, and keep your attorney informed of any updates. Do not assume that just because your priority date is current, your green card will be approved within days or weeks. Processing can still take several months depending on the workload at your specific office. Fourth, if you have an approved I-140 but you've been waiting years for your priority date to become current, and it's still not current after this month's movement, do not panic. The line is moving. It may move slowly, but it is moving. Use this time to maintain your status. Keep your job stable. Avoid any criminal issues. And ensure that your employer is still willing to sponsor your green card when your priority date does become current. If you've changed employers and you're using I-140 portability under AC-21, make sure your new job is in the same or similar occupational classification as the one listed on your original I-140. Consult with an attorney if you're unsure. Fifth, if you're in EB2 but your priority date is many years away from becoming current, consider your long-term options. Some applicants explore downgrading from EB2 to EB3 if the EB3 priority dates are more favorable, though this strategy is not always beneficial and depends on individual circumstances. Others pursue EB1 classification if they qualify, as EB1 generally has shorter wait times. Some applicants invest in education or career advancement for their children to position them for independent immigration pathways, or they explore naturalization through other means if they have access to them. These are long-term planning conversations that should happen with a qualified immigration attorney who understands your full situation. Now, let's talk about what this means for your family. If you're the principal EB2 applicant and your priority date is current, your spouse and unmarried children under the age of 21 can apply for green cards as derivative beneficiaries at the same time you apply, or if you've already applied, they should receive their green cards when you do, assuming they're in the United States and included in your I-485 application. If they're outside the United States, they'll go through consular processing at a U.S. embassy or consulate abroad. The priority date applies to the entire family unit, so if your date is current, theirs is too. However, be very aware of aging out issues. If you have a child who is approaching age 21, the Child Status Protection Act, known as CSPA, provides some protection, but the calculation is complex. Your child's age for immigration purposes is not necessarily their biological age. It's adjusted based on how long your I-140 was pending and other factors. If your child is 19, 20, or 21 years old, you need to speak with an immigration attorney immediately to calculate their CSPA age and determine whether they're at risk of aging out. If a child ages out, they lose derivative status and must qualify for a green card on their own, which often means starting over in a different category with a new priority date. This is one of the most heartbreaking aspects of the long EB2 wait times, and it's critical that you get accurate legal advice if this applies to your family. Let's also address the importance of maintaining status during this waiting period. If you're in the United States on an H-1B, L-1, O-1, or another work visa, and you're waiting for your EB2 priority date to become current, you must maintain valid non-immigrant status at all times. Do not let your work authorization or visa status lapse. If you fall out of status, you may be unable to adjust status in the United States, and you may be required to leave the country and process your green card abroad, which can trigger bars to re-entry if you've accrued unlawful presence. Keep your visa extensions filed on time, monitor your I-94 expiration dates, and stay in close contact with your employer's immigration team or your attorney. If you're already in the I-485 pending stage, you have more flexibility. Once your I-485 has been pending for more than 180 days, you can change employers under the AC-21 portability provisions without affecting your green card application, as long as your new job is in the same or similar occupational classification. You can also travel outside the United States using advance parole if you've received that document, though you should consult with an attorney before traveling to ensure you won't trigger any inadmissibility issues. You can also renew your employment authorization document, known as an EAD, every year while your I-485 is pending, which gives you work flexibility. Now, I want to address a very important point about the difference between having a priority date become current and actually receiving a green card. These are not the same thing. A current priority date means a visa number is available to you. It means you're eligible to move forward. But it does not mean automatic approval. Your green card will only be approved if USCIS or the consular officer determines that you meet all eligibility requirements, that you're admissible to the United States, that you don't have any criminal or immigration violations, that your job offer is still valid, and that all of your paperwork is in order. This is why it's so important to work with an experienced immigration attorney. They can identify potential issues before they become problems and help you present the strongest possible case for approval. I also want to emphasize that the Visa Bulletin can move backward. It doesn't happen often, but it can happen, particularly late in the fiscal year if demand exceeds projections. If your priority date is current this month and you're eligible to file or receive approval, you should act promptly. Don't wait and assume the dates will stay where they are or continue moving forward. Immigration is unpredictable, and taking advantage of current priority dates when they're available is always the right strategy. For those of you who are not in EB2, but you're in EB3 or another category, the March 2026 Visa Bulletin also shows movement in other categories, though the patterns are different. EB3 for India moved forward slightly, and EB1 remains current for most countries. Each category operates independently, and the movement in EB2 does not directly impact your category. However, the overall trends in visa availability and processing can give you a sense of how the system is functioning and what to expect in the months ahead. Let me also remind you where to find accurate, official information. The Visa Bulletin is published by the U.S. Department of State on their website at travel.state.gov. USCIS posts guidance on whether the dates for filing chart can be used on their website at uscis.gov. These are the only two sources you should rely on for official information about visa availability. Social media posts, YouTube videos, and even well-meaning friends and colleagues are not authoritative sources. Always verify information with official government websites or a licensed immigration attorney. Speaking of attorneys, let me be very clear. The information I'm providing in this video is general education about how the EB2 green card process and the Visa Bulletin work. It is not legal advice, and it is not tailored to your individual situation. Immigration law is complex, and every case is different. Your priority date, your country of birth, your current immigration status, your employment situation, your family composition, and many other factors affect your case. If you have specific questions, if you're making decisions about filing, if you're changing employers, if you're concerned about your child aging out, or if you're facing any complication, you must consult with a licensed immigration attorney. Do not rely on general information from videos or articles to make critical legal decisions. An attorney can review your specific facts and give you advice that's appropriate for your situation. Now let's talk about long-term perspective. The EB2 backlog, particularly for India-born applicants, is a structural problem created by the combination of high demand and per-country caps. The current system was designed decades ago when immigration patterns were different, and it has not been updated to reflect today's realities. There have been numerous proposals in Congress over the years to eliminate or modify the per-country caps, to increase the overall number of employment-based green cards, or to provide other relief for long-waiting applicants. Some of these proposals have come close to passing, but as of today, none have become law. Immigration reform is a politically difficult issue, and despite widespread agreement that the current system is broken, legislative solutions have been elusive. What this means for you is that you cannot count on reform to solve your situation. You have to navigate the system as it exists today. Monthly movements in the Visa Bulletin, like the one we're seeing in March 2026, are positive developments, but they're incremental. They help people move through the line, but they don't eliminate the line. If you're serious about building a permanent life in the United States, You need to plan for the long term, maintain your status, make smart career and family decisions, and be patient. It's frustrating, it's unfair in many ways, and it places enormous stress on families. But it's the reality of the current system. For those of you who are nearing the end of this process, who are finally seeing your priority dates become current after years of waiting, this is a moment to be cautiously optimistic. You've been patient. You've maintained your status. You've invested in your career and your life here. And now you're approaching the finish line. Stay focused. Work closely with your attorney. Respond promptly to any USCIS requests, and prepare for your future as a lawful permanent resident. Green card approval is life-changing. It gives you freedom to change employers, to travel without visa concerns, to pursue opportunities without immigration restrictions, and most importantly, it puts you on the path to U.S. citizenship if you choose to pursue it. Permanent residence is called permanent for a reason. It's the foundation of long-term stability in the United States. And for those of you whose priority dates are still years away, I know this news about March 2026 movement might feel bittersweet. You're happy for the people who are benefiting, but you're also acutely aware that your own wait continues. That's a completely understandable feeling. The best thing you can do is stay informed, stay compliant with your current status, make decisions that protect your immigration future, and remember that this process, as slow and frustrating as it is, does eventually move forward. Every month that passes is 1 month closer to your priority date becoming current. The line is long, but it does move. Before I close, I want to remind you about the importance of protecting your immigration status and avoiding anything that could jeopardize your green card eligibility. This includes staying out of legal trouble, avoiding misrepresentation on any immigration application, maintaining lawful status, not working without authorization, and being truthful in all dealings with USCIS and other government agencies. Immigration benefits are a privilege, not a right, and they can be denied or revoked if you don't follow the rules. The closer you get to green card approval, the more important it is to be careful and to avoid any mistakes. Also, be aware of immigration fraud. Unfortunately, there are unscrupulous individuals and companies that prey on immigrant communities, particularly during times of change or confusion like this. If someone promises you a green card quickly for a fee, if they guarantee results, if they tell you they have special connections inside USCIS, or if they pressure you to pay large sums of money up front, those are red flags. Work only with licensed attorneys who are members of the American Immigration Lawyers Association or who are in good standing with their state bar associations. Verify credentials, ask for references, and trust your instincts. If something sounds too good to be true, it probably is. Finally, let's talk about the bigger picture. Immigration is not just a legal process, it's a deeply human experience. For those of you in the EB2 category, you came to the United States to build a better life, to contribute your skills and talents, to raise your families in safety and opportunity, and to be part of this country's future. You've followed the rules, you've waited in line, you've paid your taxes, and you've enriched your communities. The delays and backlogs you face are not a reflection of your worth or your contributions. They're the result of a system that hasn't kept pace with the reality of modern immigration. You deserve better, and I hope that one day the laws will change to reflect that. But until they do, know that your patience and persistence matter, and that the goal you're working toward is worth the wait. If you found this breakdown of the March 2026 EB2 Visa Bulletin helpful, I want to ask you to do 3 things. First, subscribe to U.S. Immigration Update if you haven't already. We break down complex immigration developments every single week with the same factual, non-alarmist approach you just experienced. No hype, no clickbait, just clear explanations of what's actually happening and what it means for you. Second, share this video with anyone in your network who is going through the EB2 process or who might benefit from understanding how the Visa Bulletin works. Accurate information helps everyone make better decisions, and it reduces the anxiety that comes from misinformation. Third, leave a comment below with your questions or your own priority date and country. Let's build a community where people can support each other, share experiences, and learn from one another. I read the comments, and your questions often shape future videos. If there's a specific aspect of the EB2 process you want me to cover, Or if you're confused about how this month's Visa Bulletin applies to your situation, let me know. Thank you for watching. Thank you for trusting U.S. Immigration Update as your source for reliable immigration information, and I'll see you in the next video.